It feels like the smart, loving thing to do. You're getting older, you want to make life easier for your kids, maybe avoid the cost and hassle of probate. So someone suggests it, just put the house in your kids' names now. And it sounds so simple. So safe. But this one move, signing your home over to your children, is one of the most expensive mistakes a senior can make. It can trigger a Medicaid penalty, hand your kids a massive tax bill, expose your home to their divorces and debts, and even cost you control of the house you live in. The worst part? Most people don't find out until the damage is done, and by then it's very hard to undo. In the next few minutes, I'll walk you through, in plain English, the 4 big risks of putting your house in your kids' names, and the safer ways to protect your home that an elder law attorney would actually recommend. I'm Ray. Please watch this before you sign anything. Quick and important, I'm not an attorney, and this is education, not legal or tax advice. Transferring your home is a major legal decision with serious tax consequences, and the rules vary by state. So before you do anything, talk to a licensed elder law attorney and a CPA. My goal today is just to make sure you know the risks before someone talks you into signing. Let's start with why this idea is so popular, because the intention is genuinely good. People usually do it for one of 3 reasons. First, to avoid probate, the court process of passing assets after death, which can be slow and costly. Second, to protect the house from a nursing home or Medicaid down the road. And third, just to make things simple for the kids, it'll already be theirs, no fuss. These are all reasonable goals. The problem isn't the goal, it's the method. Simply adding your children to the deed, or signing the whole house over, is a blunt tool that creates far bigger problems than the ones it solves. Let me show you the 4 big risks, starting with the one people underestimate most. Risk number 1, the moment you put your kids on the deed, it's partly, or fully, their house, legally. And that changes everything. If you gifted the whole home, you may now need their permission to sell it, refinance it, or even take out a loan against it. Want to downsize and move closer to the grandkids? You could need every child on the deed to agree and sign. And it can get painful. If you and a child have a falling out, or they simply disagree with your plans, they can block you. In the worst cases, families have ended up in court over the home, or a parent has effectively lost the ability to control where they live. It was your house for 40 years, and now you're asking permission. You gave away something you can't easily get back. Which leads to risk 2, the one that catches the most innocent families. Risk number 2, once the house is in your kids' names, it's exposed to their problems, not just yours. Think about everything that can happen in an adult child's life. If your child gets sued, a car accident, a business gone bad, your home can be treated as their asset and become a target. If your child goes through a divorce, your house could be dragged into the settlement. If your child has debt or creditors, or files bankruptcy, the home they own can be pulled in. If your child passes away before you, their share can pass to their heirs, maybe a son or daughter-in-law you never intended. None of that is your child's fault, life just happens. But the home you worked your whole life for is now standing in the middle of it. You took an asset that was safely yours, and tied its fate to someone else's luck. And the next risk is the one that quietly costs families the most money. Risk number 3 is all about taxes, and it's the one that surprises people the most. It comes down to something called cost basis. Stay with me, because this can be worth a fortune. When you give your house to your kids during your lifetime, they usually inherit your original cost basis, basically what you paid for it decades ago. Lifetime gift equals your old basis carries over, so say you bought your home for $60,000 years ago, and it's worth $400,000 today. If you gift it and your kids later sell, they could owe capital gains tax on that $340,000 difference. Now compare that to what happens if your kids inherit the home after you pass away. In that case, the basis usually steps up to the home's value at the date of death. If they sell soon after, that capital gains bill can be largely wiped out. Same house, same kids, but doing it the wrong way can cost tens of thousands in unnecessary tax. People give the house away to help, and accidentally hand their children a giant tax bill instead. And we haven't even gotten to risk 4. Risk number 4 ties directly to something we covered in an earlier video, the Medicaid look back. Here's the irony. Many people sign the house over specifically to protect it from a future nursing home. But if you transfer your home and then apply for long-term care Medicaid within roughly 5 years, that gift gets counted and it can create a penalty period where Medicaid won't pay right when you need care most. So the very move meant to protect the house can disqualify you from the help you were trying to preserve it for. We did a whole video on the Medicaid look back, it's linked in the description, and it's worth watching. So that's the full picture: lose control, expose it to your kids' problems, a capital gains tax bomb, and a Medicaid penalty. For serious risks from one signature. Now, let me show you how a real couple almost walked right into it. Richard and Martha, you've met them before, were about to do exactly this. A well-meaning friend told them, "Put the house in your son's name, it'll save everyone trouble." They had the deed ready to sign. But Martha had a nagging feeling, so they did one smart thing first: they talked to an elder law attorney before signing. And the attorney walked them through everything we just covered: the lost control, their son's exposure if he were ever sued or divorced, the capital gains bomb, the Medicaid penalty. Then the attorney showed them better options, ones that protected the home and their son's inheritance, without the danger. They tore up that deed. One conversation, before signing, saved them from a 5-figure mistake. So what were those better options? Let's go through them. There are several tools that accomplish what people actually want: protecting the home and passing it smoothly, without the risks of just adding kids to the deed. I'll name them plainly, and again, this is exactly what you discuss with an elder law attorney. A revocable living trust. It lets your home pass to your kids without probate, while you keep full control during your life. It avoids the probate hassle, the number one reason people do the deed thing, without giving anything away. An irrevocable Medicaid asset protection trust. Set up well before you need care, more than 5 years out, this can protect the home from Medicaid while preserving the step-up in basis. It's stricter, but it's the proper tool for that job. A life estate. This lets you keep the legal right to live in your home for life, with it passing to your kids automatically at death, often with a step-up in basis. A transfer on death deed or ladybird deed, available in some states. These let the home pass to your kids at death without probate, while you keep total control and can even change your mind. Notice the theme: every one of these passes the home at death, preserving the step-up basis and your control, instead of giving it away during life. That difference is everything. If you take one rule from this whole video, make it this: never transfer your home based on a friend's advice or a gut feeling. Talk to an elder law attorney first. The reason this mistake is so common is that it's usually suggested by someone who means well but isn't a professional, a neighbor, a relative, a guy at the barbershop. And by the time the tax bill or the Medicaid penalty shows up, the deed is already signed and very hard to reverse. So what do you actually do? Nothing drastic today. Instead, get clear on your real goal: avoiding probate, protecting from a nursing home, or simplifying for your kids, and then bring that goal to a licensed elder law attorney who can pick the right tool. The cost of that visit is tiny next to the cost of getting this wrong. 5 calm steps. Step 1. Don't sign anything yet, especially not a deed someone hands you, to make things easy. Step 2. Write down your real goal: is it avoiding probate, protecting from Medicaid, or simplifying your estate? Each goal has a different best tool. Step 3. Learn which tools your state allows. Not every state has ladybird or transfer on death deeds. Step 4. See a licensed elder law attorney and ask specifically about a living trust, a life estate, and the basis and Medicaid consequences. Step 5. Loop in a CPA on the tax side before any transfer happens. Wanting to take care of your kids is a beautiful instinct. Let's just make sure that gift helps them, instead of handing them a tax bill and a headache. If this saved you from a costly mistake, or you know someone about to do it, hit subscribe and share it. I break down a retirement money topic every week. And tell me in the comments, has anyone ever told you to put your house in your kids' names? I read them all. Next time, one that surprises almost every married couple: the widow's penalty, how the surviving spouse can suddenly pay far more in taxes after the other passes away. It's one nobody plans for. Don't miss it. Take care of yourself, and take care of what you built. I'm Ray. See you in the next one.